Welcome to the Debrief, everybody. Aaron Keller, Linda Kenny Bodden here in studio with me. We have plenty of other guests joining us in just a moment. Opening statements in the trial of an Ohio cheerleader accused of murdering her newborn baby 2 days after her high school prom. Prosecutors say Skylar Richardson learned she was pregnant at the doctor's office, made no follow-up appointments, and did nothing to prepare for the baby's arrival. Prosecutors say she killed the child after giving birth alone at home and then gleefully announced that her belly was back to normal after her family accidentally learned of the pregnancy from her doctor. Richardson's family, however, said in various interviews that the child was stillborn and that the defendant buried it without telling everyone because she was afraid of social backlash. Richardson faces a total of 5 charges. The top charge, aggravated murder, accuses Richardson of killing her baby with prior calculation and design. The defendant is also charged with the other counts facing there on your screen, including involuntary manslaughter, endangering children, tampering with evidence, and abuse of a corpse. Now, during opening statements, the state told the jury that Richardson planned to get rid of the baby early on.
And on April 26, 2017, nearly 8 months after she broke it off with Trey Johnson, Brooke's worst fears were confirmed when Dr. Andrews told her that she was in fact pregnant. Dr. Andrew estimated that Brooke was already in her 3rd trimester and told her that she would be delivering a baby within a matter of weeks. Dr. Andrew conducted an abdominal ultrasound and listened to the baby's heartbeat with Brooke and determined that the fetal heart rate was strong and healthy. She kept repeating that she cannot have this baby, and she was adamant that she could tell no one that she was pregnant. Because of Brooke's reaction, the doctor gave her what are called suicide warnings, telling her that if she had any thoughts of harming herself or the baby, that he needed to know that. Dr. Andrew requested that Brooke schedule an ultrasound the very next day and that she schedule a follow-up appointment within a week so that she could get started on prenatal care. Brooke left that afternoon from the doctor's office with specific instructions to schedule a follow-up appointment. Brooke, however, never scheduled that follow-up appointment.
Prosecutors even say the defendant searched the internet for the phrase, "how to get rid of a baby." The defendant eventually delivered the child in her room without any help, and then prosecutors say there was an inappropriately joyous text to her mother.
I'm literally speechless with how happy I am. My belly is back, OMG, and I'm never, ever, ever, ever letting it get like this again. You're about to see me looking freaking better than before, OMG. Those are the words that Brooke Richardson texted to her mother just hours after she murdered her infant daughter in the middle of the night and buried her lifeless body in the dirt behind their home. Ladies and gentlemen, we are here today because the defendant, Brooke Richardson, murdered a baby that she didn't want and never intended to keep.
Perhaps most damaging was the defendant's alleged admission to the police that the baby was alive for 5 minutes. The local medical examiner ruled that the infant's death was homicidal violence.
During this interview, Brooke admitted the following: that her daughter was alive for approximately 5 minutes. She saw her daughter's arms moving a little, heard her gurgle, and heard her cry. She squeezed the baby too hard and thinks she may have killed her, and that she attempted to burn the baby after her death in an effort to cremate her. After Brooke's secret was exposed, she sent a text message to her boyfriend Brandon stating, "I love you. I'm so sorry that I never told you. Please understand that I was scared and worried and so scared of losing you."
The defense, meanwhile, said no one knew the defendant was pregnant and that the baby likely suffered from a so-called growth restriction. As evidence, the defense points to the defendant's prom dress.
So those texts that we now see after May 7th, looking back on hindsight, were Skylar focusing on the only thing she thought she could control at the time, which is her body. And she did. She put a smile on for the outside world. These texts of Skylar's selfie texts to her mother, texts constantly about her weight, were common in Skylar's life for 6 years. When Skylar went to this OBGYN appointment on April 26th, Dr. Andrew took 2 measurements of her stomach. And one, he used this tape. And this is a measuring tape from Hilltop OBGYN. It's called a fundal height measurement that he took using a measuring tape. This is his standard practice. And you'll see it in the records. He also took another measurement, which was a transabdominal ultrasound. And both measurements, independent of the other, gave him the estimation that Skylar was only 32 weeks pregnant. In this case, Skylar was 5 to 7 weeks too small. This is when she picks out her dress with her mother in February of 2017. 3 months later, she gets through her 3rd trimester. 3 months later, on May 5th, when she goes to prom, her senior year, the same dress, no alterations are made. This is a side-by-side.
Later, the defense said the baby was born dead and then buried. This is emotional, but it's the core of the legal case before us.
Sometime around 2 or 3 in the morning, she has what she thinks is the most intense pain she's ever felt. She walks to the top of the stairs. She's going to go downstairs to get some Aleve to help with the pain, and she can't keep her legs under her. She walks 7 steps into the bathroom and sits down with the urge to urinate and delivers a baby. But the baby is white. The umbilical cord is not attached. The baby's not breathing, not moving, no sounds. She grabs a towel off the towel rack and swaddles her child. She sits down on the bathroom floor, half naked and bleeding, with her back leaning up against her bathtub, holding her baby. Touches her baby. Skylar cries. She names her daughter Annabelle. She stands up. She walks downstairs. She gets a tiny little spade shovel. She walks outside. She walks out to a tree line that is visible from her bedroom window with all the strength she has left and digs a shallow grave. She places Annabelle inside, covers the grave with dirt, and drags a flower pot that weighs about 25 pounds over in front of the gravesite.
That's how the defense says this went down. The defense said jurors should not believe Richardson's so-called admission about the baby being born alive. The defense says police didn't believe Richardson's earlier stories about stillbirth and that the police put those words in her mouth.
When they have her vulnerable, when they've made her malleable, when they've used all this stuff against her, sadness about her daughter and the remains, then they say, you got to tell us signs of life. We don't think you killed her if you tell us there were signs of life. We will continue to think you didn't kill her if you tell us there were signs of life. And they repeatedly deny that this was a stillbirth.
I think I can speak for both of us. I don't think you killed her, but I think you had signs that she wasn't alive, at least just a little bit, but I don't think you killed her. But I believe that based on everything and talking to you, and I just believe that there are signs that she was alive at first. And then I don't think you tried to kill her, but I think there were signs that she was, and I want you to please, for her, just tell us what those were. How did you know at first, that she was probably alive just a little?
So what did the police tell Skylar over and over again? In fact, I think they say this 8 or 9 times in the interrogation. Gurgle. They say it a couple times before they finally break Skylar down. Guess what she says? Maybe a little gurgle. That's what he said, and that's what you'll hear. It's their word, gurgle.
One of the first witnesses on the stand was the baby's father, who was identified through DNA testing. Here is cross-examination by the defense.
At first, you denied there's any possibility that you were the father, correct?
From what I believed, yes. From not hearing anything, that's what I had assumed, yeah.
And you stated that you did everything but have sex.
I do not recall that.
Do you recall telling Detective Carter and Lieutenant Fain, who did you speak with?
I am not sure about that.
Male or female?
One male, one female.
Okay. Do you remember telling them that You did stuff for about a week in late July or first week of August, and then the next week she suddenly blocked him on all social media, and he has not spoken to her since.
No.
They got that wrong, Detective Carter did.
I do not recall that part.
The doctor who confirmed the defendant's pregnancy testified about that day in his office.
She broke into tears. She was surprised.
Okay. Was she crying?
She did.
What statements was she making, if any?
She said that she could not have she was not prepared to deliver a baby. She could not have a baby.
Okay. How many times do you think she said that she couldn't have a baby?
I remember it at least once.
The doctor went on to testify that the defendant did not seek follow-up treatment or begin to choose a hospital for delivery, which would have been helpful for insurance.
She hadn't been in to see us for several weeks, and I think by that time she would have been expected to deliver. And we said, well, we'll find out what became of that pregnancy.
And did you talk to Dr. Boyce about the appointment that you had with her back on April 26th?
Yes.
Okay. And so Dr. Boyce knew that she was pregnant going into that appointment?
Yes.
Were you involved in that at all when Dr. Boyce went in and talked to the defendant?
I was not.
Did you have any discussions with Dr. Boyce after the fact about the appointment?
Yes.
And at some point, based on those discussions with Dr. Boyce, was the decision ultimately made to call law enforcement?
Yes.
Here now for analysis on this case are four attorneys. Let's start with Judge Ashley Wilcott and attorney Eklund Mercy in Atlanta, along with Gabriela Teresa Gonzalez in Miami. So Gigi, the state's trying to add up the evidence here. No medical follow-up appointments, no prenatal care, no attempt to buy anything to take care of the baby. These jubilant text messages that the defendant had returned to her normal weight, basically bragging to her mother or trying to please her mother that was happening. Does this add up to premeditation in your opinion?
I don't think so. And let's keep this into context, because when we talk about the facts without context, they sound really bad. But the truth is that this teenage girl found out she was 8 months pregnant on the 26th of April and expected to give birth in July. Then, less than a week later, or about a week later, she actually gives birth in her bathroom. This is a shocking experience for anybody, much less an immature teenager who doesn't understand what's happening right now. And the text messages is just indicative of her difficult relationship with her mother and trying to win her mother's approval. And look, now there's no baby, so we're able to go back to being the gem of her mother's eye by being one less pound.
So you're saying this is a trail of breadcrumbs that doesn't add up. Eklund Mercy in Atlanta, I think that you're seeing this a different way, correct?
Yes, because I see that the evidence shows that there was no intent to have a living baby. We don't have the follow-up treatment. We don't have any of it. What we have is a Google search on how to get rid of the baby. That's what we have. In the event, we also have a doctor who told her that she was pregnant. And in a state, Ohio is the first, the heartbeat bill is in Ohio. So based on Ohio's laws, we already know that there was a whole baby living inside of her because we had a heartbeat. And she did nothing to prepare for a living baby. Based off of that, I think that the state has a good case. However, the state kind of mucked it up. Later on, we'll talk about that later on, though.
Oh, well, I'm curious about that opinion here. Let me jump in, though. Judge Ashley Wilcott, you're also in Atlanta for us. What's your take on this? Is there premeditation here, or is the state just not proving this beyond a reasonable doubt? Because that's the threshold the state has to cross here legally.
Right. So here's the thing, Aaron. I see a lot of juveniles who unfortunately don't always know that they're pregnant. But in this case, consider this. The jury has heard this evidence that the doctor told her she was pregnant. She knew she was pregnant. And then I think that she didn't know what to do and how to handle it. So this, to me, is not a case of she had no idea she was pregnant and, uh-oh, here's a baby. I think she did know, and that makes a difference. And to me, can prove beyond a reasonable doubt, potentially for this jury, that she's committed this crime.
You know, a lot of different opinions on this. Certainly, I agree there was enough to bring it to trial. The question is there enough for a conviction? Linda Kenny Bodden here in New York with me. Linda, what's your take on it? Same question here. The premeditation part is the part that a lot of people are really fighting about. And look, I realize we're still early in this case, but Linda, do prosecutors have enough to prove it?
Well, if you take the Aaron, the ability of like, oh, this is such a horrible situation, we're going to convict, to overcome the fact that the prosecution can't prove what the cause of death is of this child. And the first interview from this mother, Aaron, was that there was a umbilical cord was not attached. She didn't know the significance of it at that time, and that is important because that means a dead baby upon birth.
And Linda, quickly here, the baby's father, why call him to testify? I was a bit confused about what point he was making other than to try to line up some kind of point of conception at some point. But he's talking about July and August, and the calendar didn't line up for me. I didn't sit and chart it out perfectly, but was there any relevance in there?
Possibly only to confirm that the baby was full term, that it went through whatever the weeks are from August till May when she gave birth. That's the only possible reason. Other than that, it's like salacious. It's like picking up a rag.
I was wondering, you know, look, I mean, there could have been a little bit more in there. I think questioning of the father, you know, did she make plans to actually ask for your assistance in caring for the child, providing financially in some point, but there could have been a lot more there. Still ahead now on The Debrief, another step toward justice in the case of accused R&B singer R. Kelly, plus a big win for the state in the murder case against accused millionaire killer Robert Turst. The judge's reasoning on that case when we return. A federal trial date is set for this coming April in the criminal prosecution of R&B singer R. Kelly. This will be a 3-week trial in Chicago to determine if Kelly is guilty of crimes in just one jurisdiction. Kelly remains in jail pending that trial. He's accused of sexual misconduct both federally and at the state level in various mixes in Chicago, New York, and Minnesota. ABC News quotes the defense as saying there are serious factual flaws with the case. A California judge is refusing to throw out statements made by a millionaire real estate mogul facing a murder charge. Robert Durst is accused of killing his friend Susan Berman 2 decades ago. Prosecutors will be able to admit statements Durst made to a friend and to filmmakers about Berman's death and also about the death of his wife back in 1982. The state believes Durst killed Berman because she had evidence that Durst had killed his wife.
Mr. Durst himself has confessed to this crime on, I believe, 2 different occasions. At a minimum, 3 arguably. You can't get stronger circumstantial evidence than when you have somebody who's being accused of committing a murder. And instead of saying, I didn't do that, I can't tell you anything, how would you expect me to give that information? When the response is in essence, well, I don't know if I want to talk about that part, or I don't really want to go through that. Your Honor, that's an admission any way you shape it. Susan Berman was executed from behind at close range. That's the physical evidence that we have. They make a movie. The movie was sold, marketed, advertised as the story of Bob Durst. He goes and he watches the movie. And this is compelling. The one thing that bothers him, is it any of the violence against Kathy? Is it when he is depicted as having killed her? Is it as depicted as when he plans and has his cohort allegedly murder Susan Berman? Is it when he murders and dismembers the Morris Black character in the movie? Oh, none of those give a peep from him. Not one, hey, that's not accurate, that's not right, that's not correct. But when the scene comes up of him allegedly killing his dog, he's not asked. He says, Andrew, that I do not like.
And that's just some of what the state plans to introduce in this case. The judge ruled that Durst's statements to the makers of the movie All Good Things, Durst's statements to an HBO film crew, and Durst's statements to both prosecutors and his own friend all constituted good evidence.
All of that is strong circumstantial evidence that Mr. Durst was involved in, if not the killer of his wife. There has to be a belief by Mr. Durst that there was a witness to a crime. Now that witness was Miss Berman. The crime was the killing, disappearance of his wife. What's relevant is Mr. Durst's state of mind. He believed she was a witness. And that's what witness killing is. It's a state of mind special circumstance. That is more than slight evidence. That is sufficient to establish that Mr. Durst is responsible for the homicide.
Our collection of professionals is back with me once again here. Gabriela Teresa Gonzalez in Miami. Let me start with you here. There's a lot of logical jumps that you have to go through here. You've got the killing of the friend, allegedly because the friend knew about the killing of the wife. And then you have 4 layers of what the prosecution is characterizing as admissions. The judge is like, look, roll them all up, let the jury decide here, right?
Yes, exactly. The judge said, this is for the jury to decide. This is all good evidence. And truthfully, this was a Hail Mary for the defense. I'm sure they went into this knowing, but it's hard to go into a trial like this without suppressing those kinds of statements when they're so blatant and bold and outright. You know, you can't blame the defense for trying in this case. A
couple of the so-called admissions required a little bit of a logical jump there. Eklund Mercy, you know, I mean, just saying, well, you know, I have a problem with this one part of the film. Does that necessarily constitute an admission as to everything else that's in the film?
No, and that's the thing. I mean, it's relevant because it's a film about him, but the fact that he had a part, that one part, I don't know how they're going to use that. Like Gigi said, as a defense, you do what you can, you throw it out there, see what happens, and I think that's what they did. I don't know how a jury's going to make that leap. It was pretty far-fetched, but we'll see what happens.
Well, you know, it's just one of the many leaps here. Judge Ashley Wilcott, we've got about a minute left here. Bottom line, if factual issues like this are not for the judge to decide, the judge is like, okay, there's at least enough to push it forward.
Decided they're relevant. That's the judge's role. Now it's up to the jury to determine those facts. And, you know, now they're going to have to build the case brick by brick. Just because that's been ruled admissible, that doesn't mean they can prove their case easily.
And Linda Kenny Bodden with me here in New York. I'm looking at this saying, okay, you've got all of these statements. They do start to add up.
Well, they could start to add up, but the prosecution...
You're
the
going
prosecution is also relying on other evidence. And to be fair, Aaron, I told you in the break that I did give the defense my file on a witness that they're using, a handwriting expert the prosecution is using, that a judge in New Jersey threw out his testimony after hiring as a court.
So we'll be careful about asking you questions about it. Thanks a lot for joining us on The Debrief. Thanks to the panel. We'll be back here with our recap tomorrow, starting at 5.